Folks, welcome back. As I will have warned you in the introduction, I have in the studio with me here in New York City someone I consider a national treasure. I would never say that in front of him. Here he is, Hadley Arkes. That's the biggest problem I have in introducing you. How do I pronounce your last name?
Arkes.
Oh, come on.
When I get an introduction like that, I say, look, I just came in to read the meter.
Hadley
and they asked me
Arkes.
to stand around for a few more minutes. Okay.
Hadley Arkes. Now listen, I've got to tell my audience again, professor of jurisprudence, which is some type of agriculture. No, that's law. Professor of jurisprudence at Amherst College for 50 years. That doesn't seem possible. I want to ask you about your whole life and your career. You started in 1966. You ended there in 2016. You're currently with the James Wilson Institute on Natural Rights and the American Founders.
Founder-director.
Founder-director of the James Wilson Institute on Natural Rights and the American Founders. You've written many books. You've done many things. The book that will concern us principally today, the new book, is titled Mere Natural Law. We discuss it on this program, but not with you in the studio, so thank you for coming into the studio.
Right.
The title is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. Hadley Arkes, I cannot say how grateful I am to have you with us and in the studio. Thank you for being here.
It's lovely to be in with you, Eric. Thanks for inviting me in.
We've got a lot to talk about, but we have the time to cover it. Let's just start. I want your whole story, but let's start with the book a little bit.
Sure.
Mere Natural Law. Most people don't really know what natural law is. You're borrowing from C.S. Lewis with the mere, like Mere Christianity. What, in a nutshell, this is the nutshell version because we've got plenty of time to discuss it, but what in a nutshell is natural law?
Well, Aquinas and Kant would tell you it's the law that underlies all the law that tells you why you're justified in having a positive law, a law that's enacted. So we see the sign saying 65 mph, 35, and Kant would tell us, before you have a positive law like that, you have an underlying natural law that tells you why you'd be justified in having some restraints on the freedom of people to drive at speeds that put innocent life at hazard. And as ever, as Aquinas recognized, there's a need to move from the natural law to convert it to terms that apply to the circumstance and terrain before us. Not only does it underlie the positive law, it's running deeper to tell us who has the authority to make the positive law.
Now, when you say positive law,
The
because
law
you're a professor emeritus of jurisprudence, you know, you're going to throw these terms around. It's my job to say, hold on a second. So when you say positive law, what you mean is
the law that is posited or enacted, the law that's enacted.
Okay, so our laws in this country are those kinds of laws, but they are founded upon something previous, something foundational, which is the natural law. And it's your contention that all of the founders, when they gave us the Constitution, the Bill of Rights, they weren't just making this stuff up. They understood this idea of natural law.
Right. Well, the positive law, the law that's enacted by the people who have the power to put into place.
Legislators.
Well, could be Stalin, who had the power to put his law into place. So the question has to be, what is the difference between the positive law of Stalin and the positive law in America? It has something to do with the antecedent principle before the Constitution, those principles that tell us what is the rightful governance of human beings. So who has the rightful authority to making that
Okay, so any nation can have laws. So the question we're asking is, what laws are just laws? What would make a law a just law? What would make a law an unjust law? That's ultimately what our concern is in discussing this.
Right.
So when you write Mere Natural Law as the title of your book, Originalism and the Anchoring Truths of the Constitution, take us back to the founders. What was their sense of this? you mentioned Kant, you mentioned certain people, but what was their sense when they gave us our Constitution and our laws? They were not familiar with the term natural law.
Oh, sure they were. Sure they were.
They were.
Sure. Natural justice and so on. Well, look, actually, let's take it back to the mirror for the moment.
To the what?
To the mirror.
Oh, to the mirror, yeah.
You recognize the reference, the way that C.S. Lewis would draw us back to attentive to the way in which children would show the rudiments of moral reasoning, where they're arguing. It's not merely about likes and dislikes. They're having an argument of what is fitting and unfitting, right and wrong. And the conversation makes no sense unless you presuppose there's standards of judgment to tell the difference between right and wrong answers. What I was trying to do here was take it back to those principles of common sense. The founders read the great Scott philosopher Thomas Reid. Those principles of common sense on those things that the ordinary man has to understand before he starts trafficking in theories. That line of Jefferson, he said, you could give the same moral problem to a plowman, man who runs and a professor, and the plowman is as apt to get it right because he'll not be confounded by artificial rules, called them theories. The pitch is that the founders found the ground of the natural law in those axioms, those anchoring axioms of truth.
Okay, so
they're
wait,
available to people of common sense.
So C.S. Lewis, when he writes in Mere Christianity or in other things, he's referring to this idea that everyone gets this. Kids on the playground gets this. They say, you cheated. That's not fair.
Right.
And you think, well, those ideas are not arbitrary. They're rooted in something deeper, that there is this idea of what is fair and what is not fair, what is cheating, what is right, what is wrong, what is honest. And so you're saying that what you call positive law, these things have to be founded in something deeper, and that's what the concept of natural law concerns itself with, those deeper things, and who has the right to say you have to abide by this law.
Those beginning principles are those principles so grounded in common sense that the ordinary man not only knows them, but as Reid would say, has to take them for granted just to get on with the business of life.
Okay, but this brings us, I think we talked about this the last time. What I find fascinating is that if you're, a normal person working a job, raising kids, having to pay a mortgage, taxes, whatever it is, you're forced to deal with this thing we could call reality. You can't really,
Exactly.
You can't ignore reality. You can't ignore these basics. But if you're an intellectual or you're a politician or you're some kind of an ideologue who's getting paid, you have the luxury, in a sense, to be foolish. You have the luxury to ignore many of these things. And so there's a reason that many elites have always been at war with the common man, because the common man sees these things, they don't like these things. And so when Buckley famously said, William F. Buckley,
Right.
I'd rather be governed by the first, I think it was 300 names in the Boston phone book than by the faculty of Harvard College, he was making that point.
Right. That's my point. In other words, it takes considerable immersion in theories of statutory construction for a judge to deliver portentously the decision that when Anthony Stevens considers himself a woman, everybody else is obliged to respect that judgment or put themselves and their employers in legal peril and come to the judgment that that's what the Civil Rights Act of 64, 1972 must have meant when they barred discrimination on the basis of sex. Any ordinary person seeing Anthony Stevens enter a locker room could see right away what's ludicrous about that claim. But you needed to be steeped in theories of constitutional construction in order to come. It's all, as Orwell said, it's a kind of thing only an intellectual could do.
Right. I don't know who said it, but somebody else said that it's the similar version of what we're talking about, that some things are so preposterous that only an intellectual could believe in them.
Yeah, I think it was Orwell, yeah.
Earl Warren?
Orwell.
Oh, Orwell.
Yeah.
Either way, it's true. But it is fascinating because what you concern yourself with in the book, much of which I've read, I haven't read the whole thing yet, but is this idea that there are these foundational principles, common sense, and that the educated classes have increasingly become unmoored from common sense and reality, and are to some extent at present at war with reality and common sense and these grounding things. So we're going to continue the conversation. I'm talking to Hadley Arkes, the new book, Mere Natural Law. Don't go away. Hadley Arkes is my guest. My name is Eric Metaxas, and we are talking about your book, Hadley, Mere Natural Law. This is as central as it gets, as important as it gets, and I want to talk more with you about that. But I want to get your story. I at least am fascinated by your story. The idea that you were at Amherst for 50 years, for the love of Mike, how did you pull that off? 50 years at Amherst. Amherst is not exactly a bastion of conservative thinking. When you arrived there, were you politically, ideologically conservative? Were you an originalist? Where did you grow up? Let's start there.
Chicago. The days
never heard of it. Not ringing any bells.
Of the great Mayor Daley, who said the police are there not there to create the police are there to preserve disorder.
To preserve disorder?
Not to create this, but the police are there to preserve disorder.
Disorder,
right.
He was not joking?
No. It was just one of those
Daleyisms?
Like,
Most of us...
I'm offering this advice for the enlightenment, the edification, and the hallucination of this audience.
You see, most of us aren't old enough to remember
Mayor Daley, the great
that Mayor
Daley
Daley was famous. Well, we remember Daley, but, not the details. But so you grew up in the 50s and 60s.
Right.
In
Chicago. And I'm a child of the University of Chicago with my graduate degree.
University of Chicago, which
Great
is
school.
a tremendously august institution. You studied under Leo Strauss?
He was there. Yes, he was there. I took courses with him. Right.
And what's his name? Bloom was there also.
No, Alan was gone by that time.
He was gone by the time you arrived?
He'd gone on to Cornell by that time.
Okay.
Yeah.
It can happen, people. I'm sorry. It happened. He went to
yeah.
Cornell. But, okay, so you were raised in a Jewish home. Were you at all religious growing up?
Yeah. It was an Orthodox background with my family, but it not too firm going on in the years. My grandparents were quite religious. But, we sort of drifted away from that. And I think a telling moment came for me in the synagogue in Amherst when I was asked to speak I was often asked to speak at Yom Kippur. And I told the president once that, the thing I regard as the most searing question before us now, I can't speak about in the synagogue. He said, there's no question you'd want to speak about that this congregation will not want to hear you about. What is it? I said, abortion.
Oh.
He said, I'll be back. I'll get back to you.
Whoopsie daisy is
Okay.
the legal term. That's the Latin, whoopsie daisy.
Yeah.
Let me ask
So-
you, though, where were you as an undergraduate? What did you study as an undergrad?
Well, political science. I was interested in political science, political theory.
At the University of Chicago?
Illinois first. The University of Illinois. Okay.
And then you want to do law.
No, I didn't do law. Law was one of the fields of my PhD. I didn't imagine that I'd be move into it as steadily as I did move into it and be writing as much as I have written in it.
So what were you teaching when you began at Amherst?
Oh, political parties and bureaucracy, administration. I taught, of course, a seminar on urban politics, which gave rise to a book called The Philosopher in the City, of what the city would look like if we viewed the city not as simply a dense settlement with a heterogeneous population, but a polis, a moral association that teaches through the law. What difference does it make if we look at the problems arising in the cities through that moral lens? So that turned into that book, and then it turned into the book that became First Things.
Now, some people listening to this program are familiar with the magazine First Things, which published a poem of mine
Yes.
in 1999. But I want to say that First Things magazine, founded by the great Richard John Newhouse, takes the name First Things from you, from a book that you wrote called First Things.
Borrowed it.
Yeah, he borrowed it, but they're still borrowing it, and Richard John Newhouse is gone, and Rusty Reno is still borrowing it. So the magazine First Things finds its name from the book that you wrote back in 1986.
A nice bishop once in Dallas at a workshop told his colleagues that Father Newhouse took the title from my book of that name, and I said, yes. I told Richard my next book's going to be called Urology and What It Can Do for You.
That's funny.
And I want to see what kind of a journal he'd make out of it.
How about McCall's? Let me ask you now. First Things, which is the title of your book in 1986, has to itself have an antecedent. In other words, you didn't coin the term First Things.
Well, I think it was Origen who had it.
Origin.
Okay, but
Origen.
Yeah, but
he didn't write in English.
No, it was a church father, but it was common. It was common to hear things said. We have crises in the American regime. At these certain crises, things are taken back to first things, the first principles. It became common to say that. So this was first principles. That the question there was moral truths and how you know them, and people used to, take that course, seeing if they could break the argument and so on. I said this course could be done with a codicil, that everything here could be wrong, because if you accept that, you understand we are implying there are right or wrong answers, and the currency will be the giving of reasons. But I said it's always open to you to ask for re-argument of this. But see, I remember once I began the course, and I said, unusual, I said, I'm Hadley Arkes, this is First Things, and the kid gets up and said, what do you mean by that? We're going back and forth, and then the word came back to me later. Someone told this kid that if he conceded the very first thing I said, if he let it go by, he'd never be able to work his way out of the argument. I tell people,
so he had to challenge you immediately.
Right away.
It's kind of like you got to pick out the big kid, the bully, and you got to beat him up on the first day of school. Otherwise, you're never going to get through school. We're going to go to a break. We're talking with Hadley Arkes, the brand new book, very important, Mere Natural Law. Welcome back. Talking to Hadley Arkes. The book is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. Hadley, you were raised in a Jewish home. The term natural law, most of us would associate it with Catholicism, even though the ideas,
Right.
when you talk about first things and these kinds of, these are fundamental ideas, but the term natural law is associated with Catholicism. And I guess I want to ask you, I know that at some point 12 or 13 years ago, you converted to Catholicism, which I call Christianity. And I'm just fascinated about that, because what was it in your life? Were you at all religious in all these decades? Is this something that...
No, only faintly religious. There's not much theology. For Jews, it's keeping the calendar, keeping the memory of the Jewish people and with the calendar. But it was the pro-life movement. As I got into the pro-life movement, the church doesn't argue about life on the basis of faith. It simply offers a combination of embryology, science, and principled reasoning. What's the ground on which you regard that offspring in the womb as anything less than human? Doesn't speak it, neither do deaf mutes, and so on. So the point is, you don't have to be Catholic to understand the argument. The Catholic position on abortion is simply natural law reasoning. Well, I was living these circles with the natural law argument, and I was living mainly, I think, with so many Catholic friends living in those circles.
Yeah.
And finally, what struck me is that the church had really become the main sanctuary for preserving that reasoning about natural law at a time when the currents of relativism were eroding.
Well, you were
everything
hanging out
around
with
us,
some
especially
hotshot Catholics, because I happen to know that you were friends with Justice Scalia,
yeah,
and other prominent figures in
Right.
that world.
Right.
Who else were you hanging around with? Richard John Newhouse, kind of impressive.
No, my friends, the great Michael Neulman, Ralph McInerney, George Weigel. It was quite a family clustered around that about Richard in First Things,
Yeah.
the journal.
Yeah. Well, what's interesting
And
to
Michael
me...
Novak, who's so important to me.
You gotta mention
Michael
him.
Novak, right?
Well, what's interesting to me, though, you just said it, is that we're not talking about religious stuff. We're talking about reality.
Right.
We're talking about truth.
Right.
And you don't need to be a Roman Catholic or a Christian to perceive truth. It's interesting to me because when you talk about the unborn, when did that become an issue for you? The attack on unborn life. In what decade of your time at Amherst?
It was just before Roe versus Wade. As I was teaching that course in urban politics, I was trying to think through this. And my dear friend Dan Robinson, who's in the neurosciences and a Catholic, I'd say, look, it looks like a tadpole. And he said, it's not a tadpole even when it looks like a tadpole. I could take tissue from one place and and you'll have an arm going in the different place. And one of the most riveting points for me was going through the late Paul Ramsey's, you remember Paul Ramsey in his speech on reference points in deciding on abortion. And he traced it back. When does the child in the womb begin to swallow and squint? When are fingerprints available? Until he reached the point that you realize everything genetically that defines us, everything we have now, we had when we were no larger than the period at the end of the sentence as a zygote.
In fact, much smaller.
Right.
The moment we were conceived.
Right.
In that moment, the DNA, which is no different than the DNA that you have today and I have today,
right,
that was established in the moment of conception. It's at least a fascinating scientific fact to play with if you're thinking about these ultimate questions.
Yeah, and we say, well, you understand, don't you, if you had any high school biology, if your mother had removed that zygotal dot, you would not have been the next one along. That one alone was you see. And yet we find Justice Kavanaugh in his concurring opinion in the Dobbs case said, well, it's all open. Some pro-lifers actually believe life begins at conception, believes after a long tradition of embryology establishing that offspring in the womb has never been anything other than human from its first moment.
So let's since you took us to Kavanaugh, we saw recently the thing that most people that I know thought we would never see, which was the overturning of the abomination, not merely moral, but legal abomination called Roe v. Wade. Fascinating that you're taking issue in the Dobbs case, which was the overturning of Roe v. Wade, with some of the positions taken by conservative, originalist friends. Your quibble with them is what? In other words, you just referred to Kavanaugh talking about some people believe that. Don't you think he's just being gracious and somewhat coy when he makes a statement like that? I mean, he's not speaking ex cathedra. This is not an opinion, or is it an opinion?
But that concurring opinion confirmed the point that the decision of the court, first, did not even speak about the rights and wrongs of abortion, but it would not even confirm the human standing of the child in the womb. And the dissenters nailed that right away. They said the majority's opinion has nothing to do with the status of the child in the womb. If they had made that judgment, confirmed that was nothing less than a human child in the womb, it had a profound effect. When you return the matter to the state, you're saying, we're clear now. You don't have to make a value judgment whether you think it's a human life. We're clear it's a human life. And so we're going to ask you how you reconcile the taking of this human life with your other laws on homicide. And if you plant that premise in the law, you plant the premise for the Congress to act now under the 14th Amendment when the protections of law are being withdrawn from a whole class of human beings in the blue states.
And remind us, what is the 14th Amendment?
14th Amendment, no state shall, the 14th Amendment, Equal Protection Clause, for which first you gave citizenship to the newly freed slaves who ended slavery and servitude in the 13th Amendment. Now you undid the Dred Scott decision, which denied that black people could be citizens by confirming the citizenship of black people, but also confirming the power of a national government that could protect the newly freed slaves and everybody else when the protections of law withdrawn in the states.
We're going to go to a break. We're going to follow up. Absolutely fascinating. We're talking to Hadley Arkes, the book Mere Natural Law. Welcome back. Talking to Hadley Arkes. The book is Mere Natural Law. This is fascinating stuff. I want to get to all of it, really, but you just were saying that Kavanaugh, who I suppose wrote the opinion for Dobbs, is that right?
No, except Justice Alito. But Brett Kavanaugh wrote a concurring opinion.
Okay.
But he couldn't have written his concurring opinion established what the limits were of the holding because, in other words,
you understand that you are a 5-decade-long professor of jurisprudence who may be speaking above some of our heads. So I just want you to make sure that you slow down enough so that I can interrupt and ask you for clarification. So Dobbs' decision it comes down. Alito writes the opinion. Kavanaugh writes a concurring opinion. And in the concurring opinion makes a statement that you disagree with. And the statement has to do with when life begins. You are saying, I gather, that he had an opportunity to say life begins at conception. I am guessing that he and many in America would have said, I don't know that you can say that. Whether it's true is another question, but to say that in a concurring opinion, maybe, or it seems definitely, Kavanaugh thought it a bridge too far, thought maybe this is not the place to do that.
It's not a disagreement. It's a matter of getting something so profoundly wrong on the question that's central to the case. To say, when you do that, you're addressing this question of life in the womb, and you're beginning by being willing to live affably with a radical falsehood. The falsehood that you cannot say what the human standing of that child is. That's a serious thing. It's not simply that I disagree with it. It's just profoundly wrong. But it's an indication of what the code by which conservative jurisprudence is operating. That we try as much as possible to deal with the moral substance of the issues before us. We try to just deal with who has the right to make the authority to make the decision. The conservative argument against on abortion was simply that abortion was not in the text of the Constitution. Therefore, a federal judge has no ground on which to proclaim any rights to abortion emanating from the Constitution.
Okay, so here's just again to clarify and to boil these things down. What Roe v. Wade did, the reason it was ridiculous judicial overreach, is it claimed, okay, the 7, I suppose, of the Supreme Court justices in 1973 decided that somehow the Constitution makes the case for a legal right to abortion. This is a federal law. It's in the Constitution, and they give us Roe v. Wade. So now in undoing that, people who would consider themselves originalists, like Kavanaugh, say the first thing we need to do, at least what we need to do, is say that is not true. That is not in the Constitution. So I'm guessing, look, I'm not saying I'm agreeing, but just for the case of this here, is that what Kavanaugh et al. Were attempting to do is to say, that's wrong, there's nothing in the penumbra, we need to remove that. That's all we're trying to do today. So you don't think it was possible for them or right for them to merely do that. Do you think that any of them, like Kavanaugh, were thinking, well, we're going to do this today and we can get to that other thing another time, or was this their only shot?
No, I think Samuel Alito's opinion offers the possibilities for going further. He shows in his opinion that there's no principled ground on which to deny the human standing of the child in the womb, but he wouldn't extract the conclusion that arises because they're trying to keep this. We're returning this to the political arena. Somebody else will have to make that decision. But go back for a moment. Marriage was not in the Constitution when the court struck down the laws that barred interracial marriage. And the federal government
We're going to a break. We're going to have to continue this conversation in hour 2, but guess what? We are going to continue this conversation with Hadley Arkes. Folks, welcome back. We're now in hour 2, where I'm talking to Hadley Arkes, who has written a book, Mere Natural Law. And boy, we're talking about some deep and important things, and I want my audience to understand this. So you're talking about the Dobbs decision, and you're saying that Alito does not in his opinion that he writes, he doesn't take it to its logical conclusion. Is that what you're saying?
Right. He's leaving it to someone else, perhaps people in political office, to do that. But of course, what we've seen is that the Republican political class is just befuddled, uncomfortable in talking about it. You can't depend on them. But of course, he could put it in such a state that another federal judge may come back and say, well, look, it's clear that we're dealing with a human being, and now this may affect our own case. But look, Roe versus Wade didn't really establish a right to abortion. It changed the culture. It converted abortion from being something abhorred, discouraged, forbidden, into something to be approved, celebrated, promoted. The court, the conservatives in Dobbs, were simply dealing with that limited question they put for themselves. Is it in the Constitution? If it's not, we simply say it's not there. So they slew the great white whale of Roe. But they did nothing to offset all the moral implications that have arisen from Roe.
And you believe that they could have and should have?
Sure. Look, 50 years ago, the lawyers for Texas in Roe versus Wade assembled the most exquisite brief, drawing upon the most updated findings of embryology, woven with principal reasoning, to show that that offspring of the womb is nothing other than human from its first moments. The dissenters in Roe and the conservatives now never drew on those. It was quite possible for the courts to say, as they say in other cases, the state of Texas has shown compelling evidence as to why they're dealing with a small human being, and so the laws on homicide have ever been indifferent to the size and age and weight of the victim. So we simply say the legislature of Texas had ample reasons for casting the protections of the law. They could have done it that way. But that's not the way they did it. They moved on a path of saying something mechanistic. It's not in the text of the Constitution. We cannot find it.
Right.
And that's all they what they were doing in Dobbs. They're simply stopping with that.
And that is I think the word is gravamen of your argument, that
Now that's a heavy word too. Okay.
Thank you. Right, and even the root of it, etymologically, gravamen,
Right.
gravitas. You are talking about, it doesn't get more important than this, that it is the job, you're saying, of these justices, not merely to tell us what's in the Constitution and what's not, but to look to what's beneath the Constitution. So then the question becomes, how does one differentiate between that kind of thinking and the kind of thinking that would say it's in the penumbra of the Constitution? How does one differentiate from what we would call judicial overreach on the left and what I'm sure those on the left would call judicial overreach on the right, if we are to say, even though it's not there in the text, it's there? How do we, because I agree with you, but I'm not a legal scholar, so I don't understand how that works.
Well, it can't come as a revelation that people disagree on serious things. You have liberal justice in the Supreme Courts in the states, Eric, saying, of course, it must be implicit in the law that like cases should be treated in like way. Therefore, the Equal Protection Clause must be within our Constitution, and therefore it must be wrong for the laws to bar a surgery, abortion, that's performed solely on women. Now look, even if there were an Equal Protection Clause, you find it there, you still have to explain why the Equal Protection Clause would give you a license for taking the innocent life of babies in the womb. But the only way to deal with these things is to face dead on the more. If you think that judges have done some zany things, inventing things that are not in the text, the way to deal with them is to show what is specious in this reasoning. Not to say the problem lies in the text, or they invented something new.
Okay, so then the question is, you're friends with Samuel Alito.
I think he's the premier, one of the premier justices of my lifetime.
Well,
yeah.
So do I, but he's not my friend. You're friends with, you were friends with Scalia. What would they say, were they here now, how would they counter what you're saying?
I think the problem is my friends have seen the natural law as some theory hovering in the sky. They haven't seen it the way I presented here, reminding people the way the founders saw it, finding its anchor in those precepts that were available to common sense, that the ordinary man would understand. The founders would begin, for example, if you gave the ordinary man this question, Eric, Jones, accused of a serious crime, was in intensive surgery at the time the crime was committed. I think the ordinary man would say, what? Why are you prosecuting him? The ordinary man would back into what Aquinas, Reed, Kant took as the very first principle of all moral and legal judgment. It makes no sense to cast moral judgments or blame and praise on people for things they were powerless to do. Now, from that simple point, we could extract many things in our law, but that's a point accessible to anyone of common sense who would grasp it.
Do you think that folks like Alito and Kavanaugh are being merely practical? In other words, they are saying we don't think we could get away with that, and so we're not going to do that. That would cause riots in the street, or it would cause, I don't know, consternation among the chattering classes. What do you think they would posit as their reason if they were speaking privately to you, or maybe they already have done this, as to why they didn't take it where you would have taken it?
Well, that's the groove into which conservative jurisprudence has fallen. So they feel a little odd if they went beyond.
They feel a little what?
Odd if they went beyond it. People, they think
they feel a little odd. Well, tough luck. That's your job, Kavanaugh.
Yeah.
I mean, that's how I take it. I feel like saying, oh, you feel a little odd at the cocktail parties, people will look at you funny. That's literally your job.
That they may look strange among the people who have been doing this conservative jurisprudence. But my God, look.
Well, so who's going to look at them funny? Who's
people. Others,
Leo Strauss? Somebody's going to look at them funny?
Other people who do conservative jurisprudence. What you're saying, you can meet your judgment on the moral substance of the matter. Do you really have to do that? Isn't this a matter best left to the political? Well, what question are you putting back into the political?
Well, wait.
How can you address this question without addressing the questions at the very substantive question at the very core of it?
So they don't have a problem with you looking at them oddly, but they do have a problem with other people looking at them oddly. Isn't that always the issue?
I don't think they've really seen the argument presented from this perspective. I think they would agree with me. I think if when they saw the book, they see the book.
If only you'd written the book 2 years ago. But of course, you probably wrote the book somewhat in response to the Dobbs ruling.
I think. Look, you're right. In some places, to try to be statecraft, they're trying to figure what the American public would accept. But look, Micah, you've seen this. You've seen liberal judges like Hugo Black simply pronouncing one day that the federal government may not support religious institutions.
Look, I think on either side, left or right, it strikes me, this is my opinion, as immoral for a judge to think that way. It is not his job. It is your job to call balls and strikes. If the crowd goes insane and storms the field, that has nothing to do with you. Your job is to call balls and strikes. And when you allow those kinds of things to enter your decision-making process, you are not doing your job, Justice Kavanaugh or Justice Alito.
But you're saying that calls and balls and strikes says, I'm concerned with more than who had the authority to make this. I'm concerned with the substance, the central substance of the issue.
I shouldn't have said calling balls and strikes, but because I know it draws in, it has connotations. But what I'm trying to say is that you have a strict job to do. Worrying about the response to what you come up with, that is not your job. And shame on you for worrying about that. We'll be right back. We're talking to Hadley Arkes. The book is Mere Natural Law. Folks, welcome to Socrates in the City. Oh, it's not Socrates in the City. It's the Eric Metaxas Show. But it feels like a Socrates in the City conversation because I'm talking to Hadley Arkes. Hadley, you're playing the role of Hadley Arkes. Okay. I was just saying that when someone like a Roberts, anybody on the Supreme Court worries about, I mean, for example, when it seems to me Roberts said, "Oh, we don't want to look at that election interference law from Texas. We're going to say they don't have standing, whatever." What I think he was doing, I could be wrong, was he was simply saying, you know what? we don't want to rule on that. That could be troublesome. There might be riots. So we're just going to skip that. In other words, instead of thinking strictly along the lines of what it is his job to do, he's worried about stuff like some politician.
Oh, sure.
That to me is scandalous. It's immoral. And it strikes me as being at the heart of what you are talking about, that it is one's job as a judge or a justice to deal with what is in front of one, not with how someone might react to it.
Right, but what you're saying then is judges are very attuned to statecraft. Or what, Felix Frankfurter.
Is that their job?
No, but you see, it seems to go along with the territory. You see, Felix Frankfurter worrying about whether you could get that decision on racial segregation out during an election year, better not to do it in an election year. They're sensitive to these things. And now look what's happened. Look at the reactions, the reactions to where the conservative justices now need marshals protecting their homes now round the clock. So Sam Alito said he can't go fishing without a federal marshal.
Well, then resign, Sam Alito. Let somebody else do the job who has the guts to not go fishing.
Well, right now it would be somebody who would take the law in a radically different direction.
Okay.
So he knows he couldn't do that.
Okay. Well, look, we're dealing with practicalities, but my attitude is that it's one thing to be sensitive to these things. It's another thing to understand what one's job is. And unless I'm misreading you're saying it was the job of Alito and Kavanaugh to state the facts. This is what is real and true, and how people take it, that's their business. I mean, look, patriots have died for their country. So the idea that, I might be threatened on my way to the fishing hole, I don't know how to respond to that.
That's right. How do you deal with the question without dealing with the question that's central? Are we dealing with a human life? I used to ask people, do you remember talking to a group in North Carolina back in the 90s saying, we haven't talked about this, but what would you say if I told you, some people looked out and thought there are 1.2 million human lives being taken. These are really human lives. If I really saw things that way, where do you think I'd place it in the rank of interest? But just below interest rates? Would you be surprised if I took it to be a central, not a peripheral question? And George W. Bush came into town years ago to tell Father Newhouse, I'm with you on abortion, but I can't take the lead. Well, my goodness, if you say, do you really think human lives are being taken here, If you thought that 1 million human lives are being taken here, would that be serious enough for you to take the lead on? But look, there always have to be attentive to how this decision will be understood. So you understand that's always at work.
And now we understand, of course, that George W. Bush was a rhino neocon. That's a term. You can look it up in the glossary. But honestly, these things take courage. And it's dismaying to me that, it's one thing, I don't expect much of Felix Frankfurter maybe, but I expect more from Alito and Kavanaugh. So it's interesting to me that you are a lonely voice calling them.
Sam Alito, there was still a remarkable opinion because he saw the core of the matter, but he felt constrained from taking the next step to draw out the implications of his own argument.
Felt constrained how? By whom?
Because, again, there's been a code of conservative jurisprudence that are concerned. What does Scalia say on the Obergefell case? I'm not concerned about making the case for marriage. I'm concerned about 320 million Americans being ruled by 5 judges. The persistent tendency is to try to steer around those questions, say, we're concerned really with who has the authority to make this decision. We said the judges did not, and that's where we're stopping. There's a tendency to keep steering around the main question, you see.
Because of the climate
there's a concern. They think that moral judgments are somehow value judgments. There are no truths behind them. There are these value judgments.
But I would expect more from serious Christians such as we are naming. In other words, I would expect more from them, that they ought to know.
But they're working within constraints that their colleagues have developed over the years. It's very hard to break out of it. So it's just...
It's literally their job, Hadley. It's literally their job. If they can't do that job, why are they there?
Hey, take the issue. That would be a very interesting issue on this point. they citing the historical record on those laws, right? The laws that barred abortion. And all they do and say is a very mechanistic thing to say. What those laws show is that abortion has never been part of our tradition. The other side looks and says, well, doesn't mean that it can't be now. You haven't shown it's wrong. You shouldn't be telling us what other people believed. But what a difference it would have made if the judges could have said what the historical record reveals is laws in the 19th century pushed by the Medical Association with a growing awareness of embryology, recognizing the human standing of the child in the womb. We recognize those laws now because what they expressed then is as true then as it is now. There have been an entirely different rendering of the historical record, but that's not what the conservatives thought it was their technique to do. As marked by Kavanaugh could not possibly have written the opinion he did if the court was going to conclude those earlier decisions rested on a growing confidence in embryology, giving us information about the state of the child in the womb, which is as true now as it's true then, and it's to be recognized now, not because it's old, because there's something enduringly true about it.
Boy, this is heavy stuff. Let's just crack some jokes now. No, you in the book Mere Natural Law, which we're discussing, Originalism and the Anchoring Truths of the Constitution, you talk about what it is that kids know.
Yeah.
Let's get back to that. In other words, what we
point.
all know once we are, sentient enough to reason. So we don't expect a 1-year-old to know this, but 5-year-olds know these things.
Okay, great point.
Let's talk about it.
I give people this case. Let's imagine a 7-year-old who goes to school. He's beaten up by roughnecks who steal his lunch money. We ask, what do you think is the most natural reaction? 1, he feels wronged. He was set upon unjustly. 2, they must have been right. I mean, the very success of beating him up must indicate they were right.
Survival of the fittest.
Okay. Now, I don't know of anyone who would see the second one as the most plausible natural reaction.
Yeah.
But let's just say the kids have grasped that critical point of Rousseau's, that the mere capacity of some people to seize and hold power over others cannot be the source of its justification. So that you're simply backing into the notion, is to say, might makes right. If I succeed, brute power exacts its own justification. Well, the kids understand more than Justice Holmes understood. Because when Justice Holmes was given the question, what is the ground on which the majority rules the minority, the argument was for the sheer brute fact that the majority can overbear the minority. It was might makes right.
Yeah.
And so see, the kids naturally understand something that evades people who are highly read or more affected with theories.
Well, but I think there's an irony here, because isn't that the whole point of the Constitution and of having a judicial branch? The judicial branch is there as a backstop against mob rule. If everybody in America says, we're going to kill every Jew and black, can we vote on it? We vote on it, majority rules. That's when the justice, the judges would say, sorry, according to the Constitution, you can't do that.
No, Holmes has said, my job is to make sure the herd gets its way in a civil way.
Right, which is why it is shocking that Holmes rose to the position he did, actually. Isn't it shocking?
Right, of course. Yes.
I mean, to not understand that basic thing, I mean, even that a 7-year-old can understand. Even that principle
yes.
a 7-year-old can understand.
Yes, that's the point.
Gosh, we're talking about many important things. I want to go back to your biography, the story of your life. So you spent 50 years at Amherst, which was certainly not a bastion of conservative thinking.
I couldn't do it today. I couldn't survive there today.
You couldn't survive there today.
No.
But you were there for 50 years consecutively.
Yeah.
And that's an extraordinary thing, and it cheers me to think how many lives you might have touched along those decades. You just said that your first students from 1966 are now 78 years old?
Right.
Okay, we're going to stop there. We're going to come back, and we're going to unpack the mathematics of it all. We'll be right back. Folks, I don't know about you, but I'm talking to Hadley Arkes. Hadley, you were at Amherst for 50 years, professor of jurisprudence there, very distinguished professor. At some point, as we mentioned earlier, you got involved in the whole world of the pro-life movement, and eventually in 2010 decided, I want to be received into the Catholic Church, as you Catholics put it, which I would just say is you officially became a Christian. What was that migration like for you, theologically, philosophically? Were you at some point halfway there, but decided to make it official in 2010? How did that work for you?
I was mostly there, and look. My wife and I were both Jewish kids. Her parents fled Vienna in 1938. It's very tough to break away. Very tough to break away. Kind
of like tough for Kavanaugh and Alito to break away. Kind of tough to break from the herd. Right. Not easily done.
Well, the interesting moment at the Red Mass, after the luncheons, we were trying to catch up with, I think, the Scalias. We ran to Father Arnie Panula, I'd met in New York.
Wait, after the what? The Red?
The Red Mass. The Red Mass.
You think I know what that is?
The Red Mass.
I'm an evangelical.
Okay. It's the Red Mass you have before the opening of courts. A mass you have before the opening of courts. It's a big event in Washington.
A Catholic mass.
Mass. Before the opening of the courts.
Fine.
Okay. Usually the justices come, and there's a nice gathering and so on. And on the way to the lunch, I ran to Father Arnie Panula, who I met in New York. And of all things, he confronts me, and he said, "You, the most notable figure, standing at the threshold, what has been holding you back?"
Well, what year was this?
09.
Okay. So this was in New York?
No, in Washington.
But he's from New York, of course. Okay, go ahead.
I dipped into my Bert Lahr repertoire from The Wizard of Oz and said, "What's holding you back?" Courage. It's what put the ape in apricot. It's what I haven't got. So I finessed that one. Okay.
Courage.
Okay, got out of that. Courage. Okay. Now
I just want to do an impression of Bert Lahr for the rest of the segment. I just love the fact that you bring us back to The Wizard of Oz. Bert Lahr, the great Bert Lahr, courage. But listen, that's about a lot of life is about that issue.
Okay,
courage.
Let's have the second part of the story. A week later, my friend Luis Tellez was in from Princeton. He said, "I'll meet you at Mass with Father Arnes." So I go to Father Arnes, and he says, "The one strand that connects these two readings together today is courage." I said, "Okay, you're right. It's about time I did it."
I want to sing "If I Were King of the Forest" right now.
I were king of the forest, yes.
With a ruff and a ruff and a roaring rowl. But we're not going to do that. We're going to keep talking about much more important things. So he confronts you, courage, but let's be honest here. You can believe that the unborn are human beings who deserve
Absolutely
life,
not.
And you would not believe in the bodily resurrection of Jesus.
That's right.
So we're not talking about the same thing here. It's one thing for you to be hanging out with people who believe all this stuff, but I hang out with Catholics, and I don't believe in the Immaculate Conception of Mary or in everything that the Church Council laid down over the years. I wrote a biography of Martin Luther. I mean, I still don't see, you have to believe in the resurrection and the lordship of Jesus to become a Christian, believing, as Nat Henthoff did, that it's a baby in the womb. That doesn't need to make you a Christian.
That's right. But
am I being too logical for you?
No. It's your perfect example. I had another point that fled.
When did those ideas come to you? I mean, did you read C.S. Lewis? Because the title is Mere Natural Law.
Oh, sure.
Was it Mere Christianity or some of Lewis's writings?
It was a very interesting moment. We're at a telling moment in this story. I was a hanger-on during Catholic things at the Catholic social science meetings, and Stuart Swetland, who was at Emmitsburg, said he converted at Oxford because of conversations with Robbie George and Dermot Quinn. I brought Dermot Quinn to this country.
At Oxford?
At Oxford. I sat next to Robbie, and I said, "What did you tell him?" He said, beats me. resisted us. So I got over the steward, and he said, I said, Robbie doesn't know what got to you. He said, it was Dermot. Dermot told me, you could believe everything the church tells you and not be a good Catholic. The question is, do you believe in the church as a truth-telling institution? Oh boy, Eric, at that moment, that got me, because I do. And I think when the church stands contra mundum against the currents at work, my betting is the church has it right. As Father Burchell used to say, we'll hold up a mirror to show you. We'll show you what you're going to look like years from now if you continue on this. No surprises.
Yeah.
We've seen it all before. And that really did have an effect on me, that I got through it, through ecclesiology. And, of course, then you reach the one who was the founder of the whole thing. And as that eminent theologian, Robert Heron Bork, once said, if that man really came back from the grave, many things follow.
Well, yeah, that's kind of the key. He has to have risen from the dead bodily. But it's interesting that you thought of it. I'm always fascinated in people's conversion stories, including in my own, because they're all different. It's so fascinating how everybody comes to things in different ways, not always perfectly logically. It really is fascinating. In my story, which if you read the book that I gave you, it was some logic and then an absolute miracle of revelation from God. We'll be back. We're talking to Hadley Arkes. The book is Mere Natural Law. Welcome back. Talking to Hadley Arkes, A-R-K-E-S. The book is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. It is a readable book, which I wouldn't expect. No, this is very important for me. I want all of my books to be very readable. But when I read a book that's readable, it's not a small thing, because there are many great books or many important books that aren't that readable. I thought as I was reading it that how I would have loved to have you as a professor, because you're able to explain things that, in ways that people can understand, and which takes us back to this issue of
that's sweet of you to say, Eric.
Well, it's true, but it's frankly true. It is what. In other words, the things that kids know, just as you were talking about, and how this relates to the founders, because the founders, in enshrining things in the Constitution, in giving us the government that we have, they were looking to God. There's no way around it. They didn't just come up with some stuff that they thought would work. So talk a little bit about what the founders knew.
With the Declaration of Independence, they referred to the author of the laws of nature, including the moral laws. I think they found it odd to think anyone would consider Satanism a plausible religion in this country, given our understanding of the God of the Declaration, the God of Israel. So they understood that the whole thing had an anchor.
Zoroastrianism and Hinduism equally, I think they would have found preposterous, but that's when you get to this issue of religious liberty, because it's you still have to allow for people to hold certain views. The question is, what are the limits of the exercise?
They wouldn't accept the affirmation of radical evil, I think.
Of radical, I know, but I'm saying, but even Satanists today would say, "Oh, we're not,
we're not all that
radical
bad.
evil.
We're not all that bad.
Lucifer is just a mythical character, and we're just going to." But I don't want to get off on that. I want to go to.
But the founders and what they're on this.
Yeah.
Okay. Now, James Wilson, one of the premier minds among American founders, he read Burlamaqui, The Natural Law, and Burlamaqui would say, some people say law comes from a lawgiver, and others would say no, law is founded in the laws of reason. But then he'd say, we have more confidence that law comes from the lawgiver when we find it's in accord with the laws of reason.
Yeah, it's both.
Yeah, so I say, if Moses came down with the tablets and said, our Lord our God said, don't worry overly much about lying with somebody else's wife, I think the Hebrews around would have said,
hey, wait a minute, what?
Are you sure you got that one right? So there was a convergence. Our religious look, the whole thing is anchored, really. Why do you consider that biped who conjugates verbs a bearer of rights? It goes back to Lincoln's.
A what?
A bearer of rights.
Why would I consider the biped who conjugates verbs, which is a human being, a bearer of rights? Whereas a flower, a dandelion, I would not say has inherent rights.
Right. And it could be because of Lincoln's line, that no one made in the graven image was sent into this world to be imbruted. Okay, there's something different that the Christian Jewish tradition.
I'm not familiar with that Lincoln quote. No one made
In the graven image.
the graven image.
Graven image was sent into this world to be imbruted, to be treated as a nothing.
No one made in the image of God was sent into this world to be treated the way people were treating slaves in America when he made that statement.
There was I had a commission once to do a piece on the Holocaust Museum. And as I took a turn, I saw that vast vat filled with shoes as the Nazis were trying, things you could salve and use again. What came back, Eric, were those searing lines from Justice McClain's opinion in the Dred Scott case when he said, "You may think that black man is chattel, but he's a creature made in the impress of his maker. He's amenable to the laws of God and man, and he will have an endless existence. That is, he will not be even."
This was the dissenter
in the Dred Scott
in the
case.
Dred Scott case.
Yes.
You're assuming I am familiar with these things.
It's the famous Dred Scott case where the court said.
No, I'm familiar with the Dred Scott case, but I'm happy, and I am happy that I am. But I was not familiar with the dissenter's statement, which you just made. That's fascinating.
Because the point is, that he's destined to an endless existence. I say you got to measure the situation. When you realize that the Nazis looked at this situation, they thought that the shoes were the durables. You see. Not the fact that this man was destined to an endless existence. And I've said, I have colleagues in the academy who look on the world with great sympathy for the mass of mankind, but they realize they can't give the same account of the wrong of slavery, or the wrong of genocide, that someone like McClain was able to give. So this was very critical to the whole moral system of the American founding. We didn't think those moral laws came out of nowhere.
Well, I mean, that's what's so fascinating to me is that there are people trying to deny that and deconstruct that. And so we're in this ideological war at present with people who they don't believe in the sanctity of life. And look, let's face it, there are ideas so pernicious that they're at war with the idea of America, with the idea of the human person. We are now dealing with those things. And when I call upon my co-religionists to face this, it's because we haven't really seen this before. It's one thing if you had a disagreement about, well, you're a Democrat and I'm a Republican, and I'm going to vote for Reagan, you're going to vote for Jimmy Carter. That's one thing. It's one thing when pretty much everyone in the Democratic Party bought into the basics, but when you have figures in that party and figures in the culture now undermining the very basics, saying that, look, we don't believe in good or evil, we don't believe in God, we don't believe in... From those principles, you can't get a free and a just and a self-governing society. You just can't.
But what you said earlier, it's detachment from reality. We seem to dealing people who have alternate universes in mind. When people tell us they don't know the difference between a male and female, they think it's something simply assigned at birth.
We don't. Now let's be clear that we've got 30 seconds left here. I guess what we're dealing with is too complicated to talk about in this. We're gonna hold you over for another few segments, but this will have to end our conversation for today. I just want to be clear. I've been talking to Hadley Arkes, A-R-K-E-S. The book is Mere Natural Law. The CEO and founder, or the head and founder of the James Wilson Institute on National Rights and the American Founders is another place people can find you. Hadley Arkes, thank you for your time.
Oh, thank you. Thanks so much, Eric.
Hey there, folks. I have the joy of having kept in the studio Hadley Arkes, who is the author of Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution. I want to continue the conversation with him. Hadley, let me remind my audience that you were for 50 years professor of jurisprudence at Amherst College in Massachusetts. You're currently the head of the James Wilson Institute on Natural Rights and the American Founders. And we were talking about so many things. I want to just say that I know that you were friends with the late Justice Scalia. I had the privilege of meeting him once. And I have to say this, just because no one will believe me, but I've got to tell the story. I couldn't believe it when I met him. This must be 14 years ago or 15 years ago. It was at some event. I saw him, and this friend of mine, Jamie, said, oh, we got to get a picture with Justice. And I was so shy, I thought, oh, I don't want to bother him. But my friend kind of, says, let's do it. So I stand there with Justice Scalia, and my friend, with my digital camera, it wasn't yet a phone camera, takes a picture. And the moment is over. I look at the camera to see what does the picture look like, and I see that my friend Jamie Waller had inadvertently hit zoom. So what we had captured was a wonderful photograph of the chin of Justice Scalia.
That's something.
That was the whole photo, just the chin. An hour and a half later, my friend said, Justice Scalia, the photo didn't come out. Can we take another one? And he said, nope, that's it. No kidding. No kidding. Because he was that kind of a character, right? So
Right.
you had the joy of a friendship with him over many years.
People, remember, when my wife Judy died, and we had a memorial mass, and I was in the front row. There was no kneeler, and Nino was right behind me, and
You call him Nino, of course.
My friends called him Nino. He placed the cushion under my knees so I'd have something there. And David Forte, a friend, so he said, see, he was taking care of you as he was trying to take care of us all.
Unbelievable. Well,
he was just a lovable, adorable man.
the only, Romans 8:28, since you now believe that the New Testament is sacred scripture, I can quote Romans 8:28, all things work together for good for those that love the Lord and are called according to his purposes. And even the death, I thought premature, of Justice Scalia led many people in America to say, you know what, whoever we elect for the next president, we have to think about the Supreme Court. And
Right.
somehow his premature
I
death
think you may be right.
dramatically underscored that, which led to the election of Donald Trump, who said that he would put originalists on the Supreme Court. Of course, no one believed him because Trump will say anything, but son of a gun, he actually did. For me, that's a character issue.
Well,
when
he
you say
saw
you're
it.
going to do something and then you actually do it, that is fascinating. And because of that, Roe v. Wade was overturned.
He had the wit to see that it mattered to people and that he could really draw in many pro-lifers by
Yeah.
getting serious on this issue. And I think he was quite serious about getting it done. So
Oh,
he put
yeah.
in charge of it the people who knew what had to be done to get it
But there were
done.
so many Christians who didn't vote, and I thought to myself, if that were the only reason that you voted for a thrice-married, philandering New York real estate developer, I think that's a pretty good reason. I think we've had other presidents that didn't measure up, morally, like Jimmy Carter. So it's kind of it's just a fascinating thing how important these things are, how important the law is, and you taught jurisprudence for 50 years, and I want to just continue the conversation with you about. You are, in a way, on a somewhat lonely crusade because when you talk about natural law, you are, as we discussed previously, you're at least slightly at odds with friends of yours who we would think of as proponents of originalism, Samuel Alito and others, who would quibble. You mentioned Scalia. Maybe quibble is a nice way of putting it, but would argue with you and say that if it's not in the Constitution, we cannot go back to what the founders' intent was unless that's expressed in the Constitution. You take issue with that.
Right. Well, Scalia said at one point, it's a bedrock principle of the First Amendment. We may not make restrictions on speech based on the content of the speech. Well, that bedrock principle is not in my copy of the First Amendment. I think Scalia would often try to construe the Constitution on the terms in which he thinks is the most sensible, which is say he's going back to natural law. I used to rib him and say, for somebody, offer sometimes handsome examples of natural law for someone who professes up and down that it can't be done.
Now, there was a man, Scalia, a man of courage, so we cannot fault him
Oh, yeah.
in that area. So what was his thinking, or what do you suppose was his thinking?
His line was just he said we can't get a consensus on those moral truths.
What does he mean you can't get a consensus?
said-
A consensus
He said
from
there's-
whom?
He said there's too much disagreement about that. But
Okay, but that's what Kavanaugh was saying in his opinion that he
okay.
just wrote on Dobbs. Wasn't he just saying the same thing?
well,
Isn't that the idea? You can't get a consensus?
that he assumed that a consensus was absent, and therefore we're going to leave it out. But again, it's based on the notion that we have. Look, his friends would say, "Did you get a consensus on that proposition? That you need a consensus in order to have a truth? Because we didn't get our ballots."
That's where somebody says, "Oh snap!"
Okay, so you
Because
say,
seriously,
look,
what you just said. This is very important. You just said that his statement about getting a consensus. You're saying that is not itself right and true.
It reduces this proposition. The very presence of disagreement indicates the absence of truth, and of course, I have to register my disagreement with that proposition. It's a self-refuting Look, Scalia would say, let's look at the historical record. He sought safety in history. By the way, whenever he made these arguments, his liberal colleagues would simply offer a rival contentious reading of the historical record. None of this ever shook his confidence that the historical record had truth to discern. And then Neil Gorsuch tells us originalists may disagree about the judgments coming from originalism. But apparently the fact that originalists may disagree does not impair the notion that originalism has truth to discern. It was just a non sequitur. You just can't say because of the absence of consensus.
It's a non sequitur, but the fact that a giant of jurisprudence like Antonin Scalia is capable of that kind of a non sequitur is troubling.
Well, he really was a positivist, and
What does that mean?
you know, he's somebody who really wants to take. One of the first things I heard him say was that years ago when he came in to do a paper, a commentary on a paper I'd written in 1977, before he was in the courts, saying that a law that runs counter to the opinions of 40% of the population probably shouldn't be regarded as a law. It was the old idea, you can't legislate mores, you know.
Well, wait a minute. We have processes in place. We elect people who appoint judges who then do X, Y, and Z. It is not the job of the judges to worry about the people who elected the people who appointed the judges. So why are the judges looking backwards and worrying about that 40%?
Because they're worried about the judges interfering too much, inventing new rights, and injecting themselves into the political arena. So the conservative response is, no, we'll pull the judges back, try to avoid any involvement in propounding original moral arguments or even very striking moral arguments, and leave that to other people, and we're just going to make sure the judges don't overstep their bounds.
Okay, so you have just made their argument. Thank you for doing that, for playing devil's advocate with yourself, because I want to understand how it is that somebody like a Scalia or a Kavanaugh or whoever would get there. But you nonetheless, in the book, Mere Natural Law, and elsewhere at the James Wilson Institute, you're making the case that it's the job of these justices and judges to do that very thing, not to be crazy about it, but that is their job, that they're supposed to think about the antecedents to the law. They're supposed to think about what is right and true. So what do you see as the limits of that? In other words, when does it feel like it's judicially activist on the conservative side?
Well, let's take judges engaging themselves on the battlefield to question judges made on the battlefield, as we saw in the Boumediene case here. It runs against one of the deepest principles of the American regime, going back to the Revolution, that the safety of the American people cannot be put in the hands of officers, whether in Westminster or unelected judges, who have no direct responsibility to the lives that are at stake. That tells us that unelected judges should not be making decisions of this kind, which is why the judges like Frankfurt and others just backed away even with the Korematsu case about.
Okay, hang on. We're going to have We're going to hit pause. We'll be back with Korematsu. I continue my conversation with Hadley Arkes, A-R-K-E-S. The book is Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. So you just mentioned Korematsu. This has to do with judges not second-guessing military decisions. Talk about this a little bit. This is the limits of what a judge can do.
This is after they accepted curfews for Japanese. Then they're now being willing to stand back while Japanese...
Whoa. You're talking about World War II.
World War II. Japanese...
You're talking
in the
about
aftermath
FDR.
Of Pearl Harbor.
FDR in the aftermath of Pearl Harbor...
have an executive order to remove Japanese into the interior,
which is a shocking moment in American history.
It was.
So what did the judges say at that point?
Some of them, like Robert Jackson and Frank Murphy and Owen Roberts, said, no, this is really just racial discrimination. These are people who were born here. But
these are American citizens, who have rights.
Right.
And the idea that their ethnicity would affect those rights is legally nonsense.
Right. But you have other judges appointed by Roosevelt, Hugo Black and Felix Frankfurter, just taking the side of the executive and saying, judges can't be held responsible for what goes on here. Judges don't have the judgment to sort of second guess what is being done. And
that gets pretty tricky because we're talking about foundational principles, and that's like saying, when they created the Constitution, they didn't think about this stuff. Well, that's the Constitution.
But they're not. The judges may not be the best people to vindicate. They may simply have to rely on elected officials, Congress and executive, to bear these things in mind and to honor the Constitution.
So these are the limits of the judiciary, what we're talking about.
Yes, they are. When we recognized the Soviet Union, there was agreement then to put into the hands of Stalin's government the assets held by Russian nationals in New York. And Judge Sutherland, who wrote the opinion, could see this would be a taking of property, but the problem is...
Wait. I'm totally lost. During World War II...
No, I'm sorry. Maybe I'm skipping around too much. We're talking about the judges and the limits on the reach of judges.
Yeah.
Where
you mentioned Stalin.
Okay, 1933 or 4, the FDR recognized Stalin's regime. And the cost was that they had to transfer to Stalin's government the assets held by certain Russian nationals in New York.
I just want to argue about why would FDR recognize Stalin's regime. Maybe he had no choice.
It was a matter that led to the real expansion of the Communist Party in this country. But my point is this: Justice Sutherland wrote the opinion, knew this is a confiscation of property. If this arose in domestic law, it would have been challenged. But the decision on recognizing a national government, a foreign government, is bound up with military strategy. If something goes wrong, judges can't be held responsible for these things. The decision has to be put in the hands of people who do bear the direct responsibility for these things when they go wrong.
So it was deemed okay to take property from American citizens of Russian background?
Russian nationals, sure. That was the cost of recognizing the Russian regime.
But they were not American citizens, these Russian nationals.
Right.
But that's a little different.
Yeah, but when Jimmy Carter settled the question of the Iranian hostage crisis, there were many Americans who were owed
Carter
property in.
He settled the Iranian hostage crisis? I was under the impression that it might have been Ronald Reagan.
When this thing was being settled. You're
well,
right,
I know.
Right.
We know that Carter was attempting to settle it.
Yeah, but as the thing was in the works.
Okay, so that was Carter.
As the thing was in the works, it was understood that there are American vendors who were owed money by the Iranian regime, but they lost it. It was part of the settlement. Part of the settlement was we'll get the hostages out, we'll waive these other things, and.
Well, that's like eminent domain. I get it.
Okay,
There's
we
limits.
can put that aside.
We can put that aside. What should we talk about?
I like to go back to the beginning because at one critical point it is worth mentioning that the founders knew that these principles that were there, they drew upon, were there before the Constitution. The Constitution was not the source of their understanding.
It was an expression of their understanding.
Right, and they didn't put in the Constitution everything they knew, but those principles were there before the Constitution, and they understood that they'd be there even if there were no Constitution. So as John Quincy Adams said, that right to petition the government, it would be there even if it weren't mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution. And John Marshall, later it's in the old Dartmouth College case, said, to impose upon somebody a contract they did not wish may be as bad as impairing the obligation of a contract they had willingly made, an argument we'd hear during Obamacare on compelling people to buy insurance. And Justice Story in his commentary, famous Justice Story in his commentaries would say that principle, that imposing on people a contract they did not want, that would be true even if it weren't in the Constitution. And so people were constantly aware that in order to explain the Constitution they had wrought, they had to go back, go back into those principles that were there before, in order to lay out the ground of their own judgments.
Now, who do you think is the ultimate audience for your book, Mere Natural Law? Do you suppose that there are law schools where they will get this and they will raise up lawyers who will become judges, who will understand these things? Because it seems like the ship has sailed with the current group.
Except that, as Chris DeMuth said in his commentary wrote on the book, that the sense is taking hold that something's wrong with a morally agnostic Constitution. People get the sense that something has gone awry. So younger people become aware of something. They want to hear more.
We're going to follow this and other sentences. We'll be right back. Welcome back. We're talking with Hadley Arkes, A-R-K-E-S. The book is Mere Natural Law. You were saying, just before we went to the break, that there are younger people who sense something missing. That, in other words, that if we proceed as agnostics, as secularists, we can't really have the laws that we have. We can't govern ourselves. That this thinking seems to be catching hold.
Yes, and by the way, you said it's a readable book. I hope it be read by ordinary people, businessmen, ordinary citizens. And yeah, I think it may take hold among young lawyers, people in law schools who are told, you'll never hear anything about natural law. If you want to hear anything about it, maybe this is a readable version. We have a seminar.
Anybody, look, let me interrupt. Anybody thinking about law school or in law school or practicing law should read this book. That's a fact. I say that not to do any favors to Hadley Arkes, but to do favors to those to whom I have just been speaking honestly. No, I mean it, because I'm not a lawyer, and it is readable, and it's actually fascinating, and it's also very, 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 very important. So please continue.
That's sweet of you. We have this seminar in the summer for really gifted young lawyers coming out of law school.
Who does?
Our James Wilson Institute. I'm sorry, I use the we.
James,
Wilson
what's the
Institute.
website?
James Wilson Institute. JamesWilsonInstitute.org.
Okay.
JamesWilsonInstitute.org. I hope you'll visit it.
Okay.
So we have this. One of our programs is a seminar we have every summer for some gifted young lawyers coming out of law school on the way to clerkships. And we had a first 2 years ago. We're having of a young woman who had already been clerking at the Supreme Court. She had clerked for John Roberts, and she's coming to us. And I said, "What are you doing here?" And she said, "I want to get what I never got at Harvard, at the law school." Let's see.
And I'm certainly not getting from Roberts, but I can't talk about that right now. JamesWilsonInstitute.org. Well, listen, I'm thrilled to hear about this, and I hope that young lawyers and law students will think about this, because part of the reason we're having this conversation, part of the reason you wrote this book, is because we've come to a place where these things need saying.
Right.
Where it's not, we've been drifting for a long time, but these things do need saying right now, and I'm glad that you're saying them. Was there anything that prompted you, specifically that prompted you to write this book? Was it the Dobbs decision?
No. It was on the works before the Dobbs decision, and it was really, my dear friend Dan Robinson, who wrote this did 18 books and lectured at Oxford, said he wanted at his tombstone, he died without a theory. And he was really drawing upon Thomas Reid about those things, those precepts of common sense that ordinary people had to understand before they start trafficking in theories. You know, before the average man would banter with David Hume about causation, he knew his own active powers to cause his own acts to happen. That's that. Why don't we do something like this? Take it back to those grounds of common sense that people had to understand before we got into theories of constitutional interpretation and offer that other angle on the natural law.
Well, that's a big part of what you say in the first part of your book, the part that I have already read, Mere Natural Law. And it really is very important, that idea that once you get to theories, to these formulations,
Right.
You begin to at least potentially run into trouble, and you need to understand what precedes the theories. And we have a class of people, the cultural elites, who seem to traffic exclusively in theories.
That's right.
They are unmoored from reality,
That's true.
from the
That's right.
basics.
That's it.
And that's, to me, at the heart of many problems in the world through history, frankly. I mean, I could even say, as a pro-Catholic, non-Catholic, that's kind of what Luther bumped up against in the high medieval church. That
Sure.
things had gotten so Baroque, before the Baroque period, but that there was more, fidelity to Aristotle than to the Scripture, or there was more things had gotten complicated and needed to be simplified. We needed to go back ad fontes,
Finding home ground.
and that's a healthy thing. And now and again, that becomes more important than at other times. And it seems like we're at that point right now.
I hope so. I think people are willing to take a look at this again, which is, we've drawn to ourselves some federal judges. One of our projects is a seminar involving bringing together some gifted teachers of philosophy and law with some stars of the federal bench who want to take this seriously again and get hold of it. So we've had Edith Jones, Alice Batchelder, Dermot O'Scanlan as our regulars, and it's really taken hold. More judges are coming over, showing an interest in it. So, again, it's to say we're not dealing with something. The old line was that Socrates brought philosophy down out of the clouds to bear on questions of right and wrong. We say we're trying to bring natural law down out of the clouds.
Yeah.
To show how it's accessible to ordinary. It's not a theory, but it's something that pervades our judgment every day. I used to raise the point, to ask whether a judge could get through his day without using this is rather like asking, can I order the coffee without using syntax? I mean, it pervades everything they do, and they're just not aware. Its fundamental quality may be shown in the fact that we use it when we're hardly even aware that we're using it.
Well, that's a pretty good place to end, much as I hate to end. The book is Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution. Hadley Arkes can be found at the James Wilson Institute.org, jameswilsoninstitute.org. And how many students do you take per summer for that program?
About 16, 17.
Just a handful.
Yeah, we may try to do a second round because
Yeah.
we're getting so many terrific applicants for this.
Well,
and it's just hard to make a.
This is very important stuff. jameswilsoninstitute.org. If you know anybody thinking about the law school, jameswilsoninstitute.org. And for the love of Pete, get a copy of Mere Natural Law. Hadley Arkes, thank you so much.
Thank you. Wow. Who could sell a book better than that? My good. Thank you.
We'll
Thank you,
find
Eric.
out. Thank you. Folks, this is your daily reminder to please go to mypillow.com or mystore.com. And to get huge savings, use the code ERIC. If you don't believe me, here's some celebrity friends.
Mama said to use the code ERIC.
Use the code ERIC.
Eric.
Thank you. Thank you very much.